Hello.
Hello.
All right. Are there applications in these cases?
Sorry, Your Honor.
Court is calling 2025 CR 008396 and 2025 CR 014167, State versus Melissa Renee Paez. Can I have parties announced for the record?
Trey Mauer for defendant.
All right. And are you Ms. Paez?
Yes.
Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. In each cause number, Ms. Paez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And did you sign it? In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictments as presented in cause number ending in 9-6?
No, Your Honor, state moves to waive the enhancement allegation as well as count 2 and proceed solely on count 1.
Any objection?
No objections.
And are you proceeding on the indictment as presented in 6-7?
No, Your Honor, state also moves to waive the enhancement allegation in that clause.
Any objection?
No objections.
All right, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
In cause number in 9-6, you're charged with fraudulent possession or use of credit card or debit card, 10 to 50 items as a second-degree felony, range of punishment. I'm sorry, you're only proceeding on one count, correct?
Correct.
Okay, it's just the way it's printed out. We're good though. All right, the range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your
If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. In the cause number ending in 6-7, you're charged with false statement to obtain property or credit, $30,000 to $150,000 as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call him the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Paez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, or reentry. Did you understand?
Yes, Your
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, the state is waiving the enhancement. And in cause number ending in the cause number ending in 9-6, the state is proceeding on count 1. And in each of the cause numbers, the state is asking that your punishment be assessed at 10 years in the prison. There's a $1,200 fine. State is opposed to your application. They're asking that the causes run concurrently. They're taking in consideration 2025 CR 014168, 2025 CR 015020, and 2025 CR 015019. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? In each cause number, did you review the waiver of appeal paragraph? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There are not, Your Honor.
And the cause number ending in 6-7, outside the agreement, there's to be no contact with Mission Mitsubishi at 9800 San Pedro, and there's to be no contact Did you understand those were recommendations from the state and the court does not have to follow that recommendation? Then in cause number 2025 CR 008396 to count one, how do you plead?
Guilty.
And in cause number 2025 CR 014167, how do you plead?
Guilty.
State in each of those cause numbers, do you have any evidence to support the plea?
Yes, Your Honor, state offers states exhibit 1 and all attachments in both causes.
No objections.
All right, state you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, the state is opposed to your application. If you would like a PSI and a TAP evaluation, it'll be 8 to 12 weeks. If you would like it brought back sooner, I will listen to whatever witnesses or evidence that's submitted to me and make a decision.
Your Honor, after speaking with my client, we have a request if the court would consider signing the dismissals on the 3 cases that were taken into consideration in light of her plea of guilty and plea onto these 2 cases. If those 3 cases are closed out, and if the court would additionally consider reducing her bond slightly on the 2 that she has pled on, so she could take those full 8 to 12 weeks, organize her witnesses and people that she would like to be here on her behalf, and make sure that she has everything lined up for whatever the court does decide at that point. I believe that's what we are requesting, Your Honor, if the court would consider dismissing those 3 and possibly just slightly reducing the bonds on the 2 that she's pled on so she can organize everything and take the full time for the PSI.
All right, so with regards to bond reductions, you'll have to file a motion and then I'll hear it so that the state can be prepared.
Okay.
And if the state is waiving notice, just whenever you all get together, the court will do that. Now, with regards to the dismissals, any objections to the court signing the dismissals now or?
Object, Your Honor, because that is something that ensures or will be dealt with at the resolution depending on what this court does.
And maybe I should have discussed this with you beforehand. If I may say, Your Honor, I've understood previously that if someone enters a plea and then does not return, that that plea can be, the court can say we're not going to accept the plea and that the full range is open. I believe that on its own will be sufficient to guarantee that she'll be here, and she'll accept whatever the court decides at that point.
All right, so this is what I can tell you all. This is new to me. With regards to the court signing the dismissals, the signing of dismissals to the court appears to be a part of your plea bargain agreement. And until the plea bargain agreement is accepted by the court, which it hasn't been accepted, right? The only thing that I'm doing is memorializing for the record that this is your plea bargain agreement. I have not accepted it yet. However, again, it's novel to me. If somebody brings me some case law that says that the court can make a decision with its own discretion to dismiss cases if a plea bargain agreement has been entered to but not accepted by the court, I'll consider it. But my understanding of the law is that unless the state says they're in agreement to these cases being dismissed now, they're really not to be dismissed now, because your plea bargain agreement, I haven't even accepted it yet and entered a sentence. I've just accepted the contract that you want to enter into. Do you understand? All right. So, but again, if somebody brings me case law that says something differently, I'll review it. I never said I know everything.
We take a quick step back just so I can discuss with my client very briefly, Your Honor.
Sure, and then let me know if you all want the 12 weeks or not, 8 to
Okay.
12 weeks or not.
Thank you, Judge.
Sure. All right, Norma. The attorney hasn't come back, but I know he said that he did not want the PSI on Mr. Smith. When do you want that brought back?
He said he's on his way back.
Ah, okay. And usually this is what I've discovered. When we have a docket that is not as full, we still end up being here for a long time. But I like to make sure that I hear everything. And this is what I tell people about judges. Well, about me. I don't claim to know everything. I don't know every law under the sun. But if somebody brings me some law that says, Judge, you're incorrect, I'll listen to it and change it. Or if it's something that's novel, like that is novel, that's the first time that's been brought. But if he brings me case law and says, oh, no, Judge, it's within your discretion, then I'll hear it. Yes.
Your Honor, my client has decided to do not the full PSI. Will come back sooner rather than later.
All right, so let's go. We're back on the record. If you'll come forward. All right, so are you asking that the PSI be waived? All right. And then with regards to TAP evaluation, are you asking that that be waived as well?
Is it going to be the same wait time, Your Honor?
Vashon, how long is TAP just for a TAP evaluation? TAP evaluation is 4 weeks.
We'll do the TAP evaluation, Your Honor.
All right, so there is a request for a TAP evaluation. It's in both cause numbers. It's 2025 CR 014167 and 2025 CR 008396. All right, Ms. Ferguson, what date? Yes, and Ms. Abrams, if they can expedite that and maybe get it to us sooner than 4 weeks, we'll try.
I can do February 25th. Oh, I'm sorry, the 26th, Judge.
February 26th. And if for some reason, if they're able to do it sooner, they'll let your attorney know.
Yeah.
All right, you're welcome. Is there anything else?
Nothing to prevent.
All right, with that, we'll close the record.
Thank you, Your Honor.